Okay. Case number 21-2315 LT Soap versus Pam.
Yes, Your Honor.
Okay, Mr. Soap.
Yes, yes.
Mr. Pam actually came up to the court. He's having trouble on Zoom, so my court officer is trying to assist him with logging on. So,
I figured it out. I figured it out, man.
Okay.
What it is?
Are you
Yes.
Mr. Pam?
Yes, ma'am.
Okay. Hi, Mr. Pam.
How you doing?
I'm well, sir. Mr. Pam,
Yes.
you're being a termination of tenancy case that's been filed by Mr. Soap against you. You're entitled to be presented by counsel.
He moved, Your Honor, he moved out.
Okay.
Okay.
Are you okay?
But I moved out because it's I got pictures of everything in my basement. My basement floods. There's poop in my basement. He don't want to come do anything, but take my rent money every month and not come do nothing. Every month.
That's 3 months, Your Honor.
That's what I'm trying to avoid.
I got pictures.
Hold on, gentlemen. Hold on, gentlemen.
Yes, yes.
Mr. Soap interrupted me and I didn't get to finish.
Sorry, I don't mean to.
I'm going to start all over again, gentlemen.
Okay.
Mr. Pam.
Yes.
This is the date and time scheduled for your first court appearance on a termination of tenancy case with regard to the property located on Spring Hill Street. You're entitled to be represented by counsel. You can certainly hire your own lawyer, but if you're unable to hire your own lawyer, we do have Lakeshore Legal Aid available to assist, and they are on the line today. Would you like to speak with a lawyer today?
Yep.
Okay. So here's what I'm going to do. I'm going to adjourn this matter to give you the opportunity to speak with an attorney. We will see all parties back on this matter on 17th. Yes. We'll see all parties back February 17th at 11:15 a.m.
Okay.
You got that date, Mr. Soap?
Yes, Your Honor, but he moved already and he emptied the house. So it's empty now. I have to secure the house.
Have you the keys back?
The thing is, he said he just got the dog there. And I'm worried about, damaging anything there because he moved out everything. He told the council. The council, he told you already he's moving out. He moved out.
Do you have the keys back?
No, Your Honor. I have my extra keys.
Right, but you don't have the keys back.
Because he's traveling, Your Honor, all over. So I'm not sure when he'll be there and all that stuff. So
very good. Then we're just going to keep everything right where it is. And Mr. Pam is going to speak with an attorney, and we'll see all parties back on the 17th of February at 11:15. Thank you.
Thank you.
And Your Honor, I believe all of our attorneys are tied up at the moment, but Mr. Pam wants to wait. He can, otherwise I can give him our 1-800 number that he can call.
It's your pleasure, sir. Mr. Pam, you're muted. We can't hear you.
I said, would I get the paperwork or phone number?
All right, Mr. Pam, I'm sorry, we couldn't hear you.
I said, how can I get the paper? You said I'm gonna get some paperwork?
Mr. Pam, I'm from Lakeshore Legal Aid. All of our attorneys are busy speaking to their clients. You can wait until one becomes free, or I can give you our 1-800 number that you can call to speak to somebody for legal advice.
Okay, how long will it take one to get free?
I can't honestly say, sir.
Okay.
I mean, it could be 15, 20 minutes, maybe.
Okay, yeah, I could wait. Yeah, I could wait. You want me to wait on hold or form, or would they call my phone back?
Just wait on hold.
Okay, all right.
I have to wait, Your Honor, too?
No, Mr. Soap, you're all set. You can hang up.
Okay, thank you.
Parties ready? Dillard Homes Realty versus Tracy Moore, 21-1901 LT.
Ready, Your Honor.
Morning, Your Honor. David Morosky for the defendant, Tracy Moore, as listed in the docket. And Your Honor, just so you're aware, it has her name misspelled. It's Tracy, spelled Tracey.
Okay, very well.
And she
Now,
actually, yeah, and she
case-
actually, I'm sorry, she actually goes by Moore hyphen Paisley, Pasely. I'm Ley, sorry.
Okay, very good. All right, gentlemen, how are we proceeding today?
Thank you, Your Honor. Melvin Babby appearing on behalf of the plaintiff. Your Honor, there was an order at the last adjourned hearing that an answer be submitted within 7 days. We just received an answer yesterday on this matter. We're seeking that we receive a judgment in favor of the plaintiff at this time.
Your Honor, I apologize for filing the answer late. I had prepared it before I went on vacation in December. I forgot to have my office send it in, and I just discovered that it hadn't been filed. I filed it late yesterday, so my apologies. Your Honor, this is a case set for termination for a hearing pursuant to notice of appear. This is not a landlord-tenant relationship, Your Honor. This is a claim of superior title. Mr. Babby's client is claiming that they hold title pursuant to a quitclaim deed, which was given to them by MGC Properties. However, my client previously held title from MGC Properties. She's claiming that MGC Properties forged her name to a quitclaim deed, sending it back to them, who then sold the property again to Dillard Homes Realty. There is a triable issue of fact in this case as to who holds proper title to the property. My client has been living in the property for years, been paying the taxes. I understand Mr. Babby's client may have bought the property last summer, but there is clearly an issue that needs to be presented to a trier of fact, Your Honor, and we ask that this case be set for a bench trial. I would like to subpoena the notary on the deed out of my client's name. He coincidentally happens to be the same principal who sold the property, Mr. Babby's client. So there's clearly some issues here. It's not a straight up, I'm entitled to possession of property like it would be in any other termination of tenancy case, Your Honor.
How long did you say Ms. Moore had been living in the property? Do you know, Mr. Morosky?
Yes, her quitclaim deed is dated February 28th, 2018. Now, she may have been in the property prior to that. I don't know. She should be here today. I spoke with her this morning. She
I'm
said,
here.
okay.
I'm here.
Miss Moore Paisley, how long have you been in the property?
I've lived here since 2012.
Okay.
Okay, Mr. Babby, do you have any objection to the court setting a trial date?
Yes, Your Honor. At this time, the defendant has not complied with your previous order. The previous order required an answer within 7 days. The answer is deficient in and of itself. The answer submitted to the court does not provide any basis for any of the denials as required by court procedures, by the court rules. So, I mean, at this time, even if there is a tribal issue of fact, I mean, they missed their mark. They've had since the notice to quit was submitted to them on September 17th. The complaint was filed on October 18th. There was an eviction hearing, the initial hearing on November 18th. The second hearing was on December 6th. They were required to file their answer within 7 days. There was no answer filed. We're at the next hearing now. It's February 6th. My client has proper title to this property. If there was an issue to that, there should have been in the answer a definitive statement as to what their denial was regarding my clients being prejudiced at this point from not being able to rent out this property. The defendant was due to lose this property to property tax foreclosure, which is imminent, and my client is now teetering whether to pay these taxes or not, to catch up and stop the property tax foreclosure. Even if somehow she were to provide evidence that she is the valid title holder, I think she's due to lose this property to tax foreclosure. So I don't think it's appropriate at this time to continue to adjourn this matter to set a pretrial schedule, as the defendant has not complied. And ultimately, if Your Honor is willing to do that, then we would ask that my client be entitled to 2 rental payments paid into escrow. And then once it's determined whoever the rightful owner is, that a fair market value for rent start being paid towards escrow to go towards my client in the event that my client is successful. Since this is potentially, if this does go forward, it could take clearly a matter of time before it's resolved, since we've started this first issue in October and we're now 4 months later in February. So we're at the mercy of Your Honor, and those would be the requests we would make in the interim.
Your Honor, if I may.
Yes, sir.
Once again, I apologize for the delay in filing the answer. That is my fault, not my client's. And I don't wish for her to be penalized because of that. Like I said, it had been prepared, but it had not been timely filed. And that was oversight on my part. The answer is sufficient, Your Honor. It denies allegations as untrue as required. It does not just do a straight up denial. Additionally, the affirmative defenses clearly state the basis for why the denials are being made. And that is namely that, for example, affirmative defense number 10, defendant's name was forged to a quitclaim deed, fraudulently giving title to plaintiff's grantor of the subject real property. I don't know how more specific I need to get with that, Your Honor. That's the heart of the case, and that was raised at the last hearing as well. So Mr. Babby knew the basis of the defense, and we raised that at the last hearing, Your Honor. So in the court rules for summary proceedings do allow for verbal answers to be given at the first hearing. So it's not as if this is something that Mr. Babby's been totally unaware of. Number one. Number two, the issue property taxes is completely irrelevant. Now, if the court wishes to submit an order requiring that property taxes be paid, that's something else. But I don't think that it's an issue for this court. And additionally, I don't think Mr. Babby's client is entitled to rent. There's no rental agreement here. So there's no reason that my client should have to pay rent to the court on top of what she additionally has to pay for utilities and the upkeep of the home while this case is pending. We're just asking for a brief adjournment to the next court date, which I believe is the 17th. That would give us enough time to subpoena Mr. I believe his last name is Miles, Ibrahim Miles. He's the notary that notarized my client's forged signature. He's also the principal of the company. Additionally, Your Honor, he's been harassing my client since this case has been filed, basically telling her that she needs to resolve this case. So clearly there is some wrongdoing on Mr. Miles' behalf, and I would like to put him in front of Your Honor to explain how this deed came about and why he's telling my client that she should resolve this case so he can sell the property twice, to both my client, who's paid valuable consideration, and to Mr. Babby's client. And if that's the case, that the deed is deemed to be forged, Mr. Babby has a right to recover the $5,000 his client paid for this property. So, considering the financial amounts that are at stake versus my client being evicted from a house that she's been in for 10 years and be made homeless because of a forged deed, I think is something that needs to be taken up with the trier of fact.
Your Honor, if I may.
Go ahead.
Thank you, Your Honor. I think the issues today are whether there's the tenancy, it needs to be terminated. The tenancy is determined by the ownership of the property. It's a month to month at this point. The defendant had ample time to make these arguments. My client is being prejudiced by having to wait. Now, whether Your Honor orders property taxes to be paid or rent to be paid in escrow, I think is appropriate. If this matter is going to continue, the rental amount won't go to my client, it will go into escrow. And if it's determined that my client is the rightful holder of title, then those funds would come to my client, which he would be due since he is the valid owner of the property and he's being prejudiced from being able to let this property out to future tenants. There are carrying costs that he's required to incur as owner of this property, and potentially having to pay those property taxes. So whatever the court decides, we think a valid escrow order for rental payments would be appropriate.
Your Honor, may I respond?
Yes, sir.
Your Honor, there is no relationship between the two parties. There is no month to month, as Mr. Babby suggests. They're essentially claiming a right to the property based upon my client not having a right to occupy it, essentially a trespasser. So there is no month-to-month tenancy as suggested. And number two, just because he has a deed, a quitclaim deed, does not give him the right to evict without having a triable issue on whether or not that deed is enforceable. I may hold a deed to the Ambassador Bridge, but that doesn't mean I own it. Your Honor, if there's a forged deed, the law is clear that anything coming out of that deed is irrelevant. It's void. So there has to be a triable issue on whether or not that deed from my client, who, by the way, the deed is through Tracy Moore, not Tracy Moore Paisley, her correct name, back to MJC Properties after she had been living there. Whether or not that deed is valid, I think is an issue for the trier of fact.
Your Honor, would we by chance have the opportunity to go into a breakout room to discuss before any decisions made?
Sure. We'll put you in there right now.
Thank you, Your Honor.
Thank you, Your Honor.
Would it be just the two attorneys, or would you like to miss?
Attorneys, just two attorneys. Unless you want, Mr. Bobby, do you want some of the tenant in there?
That's fine. That's fine. It doesn't.
Okay. Do you remember which one? Ms. Moore, Ms. Moore, Mr. Morosky, Mr. Bobby.
Thank you.
All right. This is.
Okay.
I believe Mr. Babby is speaking to his client regarding
Okay, I think everybody out because we're wrapping up.
I understand. He was just speaking to his client regarding possible.
She's out, or no, he's representing Mr. Morosky's representing Ms. Moore. So Mr. Bobby is representing Dillard Homes, so that's who he's probably talking to. Okay, well, just let me know. I think I gave you that file back by mistake.
Did y'all get anywhere in the breakout room? Ms. Morowski?
Oh, yeah, there was a settlement offer. I think he's talking to his client about it.
So y'all don't need another court date?
Well, no, he doesn't have, he was looking to get, my client made a demand, and his client, he's speaking to his client about whether or not they're going to accept it. If not, then obviously we go forward. So
All right, we'll see.
hopefully he's done soon.
Okay. Okay,
here we go.
Hey, Dave, I'm ready to jump back on if you are.
we're here. Did you come up with anything? This is the clerk.
Do you need to speak to me, Mr. Babby, first?
Yeah, can we jump in a breakout room?
Okay, well, this is what the judge decided. The next court date is March 17th. If y'all come up with something before there, just submit it to me.
I'm
March
sorry.
17th to 30.
Can you repeat that? Did the judge adjourn it?
No, if you come up with something, you can just submit it to us because the judge is gone. So if you come up with something, just email it. If not, your next date is March 17th at 1:30.
Is that a trial date?
Yes, she said it for that.
Okay. Mr. Babby, you want to call me then, or?
I guess it's already set, right? So is that what I'm hearing?
No, if you work something out, just submit it to us and it won't be a date.
Well, because if there's a trial date, we would want the dates for discovery, a pretrial order. Is that something we would submit that wouldn't get entered today?
Well, the judge is gone.
Okay, I guess we'll submit a pretrial order, order, I guess, regarding those dates. And
If you, Mr. Babby, if you want to talk, I'm available till 2 o'clock today.
what's your number? I can call you right now.
248-443-8068. And I have an extension of 4354. Ms. Moore, I'll give you a call when I'm done speaking to Mr. Babby.
All right, thank you.
You're welcome.
All right, David, I'm calling you now, okay?